I'm Tarun Khurana, and I'm from Khurana and Khurana, and thank everybody here to join on this very pertinent topic that we're going to talk about today, which is UPC. This topic has been going around for several years, and it is high time that Indian and global companies now take a call because of the impending deadline that is coming up on deciding of whether to opt out of the UPC or be a part of the system. And therefore, we thought it was very pertinent to have it now, which is towards the end of April, because then we only have 1 month left. So I would thank everybody who's taken out time to join, which I understand are in-house counsels and practicing professionals who've been able to take out time and join on this very important topic. I have with me Dr. Sandeep Basra. She is a partner at Hasseltine Lake. And I also have Matt and Nina who will be co-speaking, and all three of them are wonderfully experienced patent attorneys practicing in the pharmaceutical and other technology areas allied in the space, and they'll be taking on. And without any further ado, I think the agenda is very clear. We are talking about what the UPC would be, what are the timelines that we're looking at, what are the implications of the choices that we make, and what happens if we don't make any choices within the coming 40 days or so, as far as our corresponding European patent families are concerned for the applications that we carry. So Sandeep, over to you. I've known you for several years. Thank you very much for agreeing to talk. And I don't think there's any better team or person to sort of have on this particular topic, because you've worked this extensively over the years on this space. And thank you very much. And over to you, ma'am.
Thank you, Tarun, and thank you for organising this webinar with us. We're very delighted to join up and partner up on this. And today, as Tarun mentioned, we will be talking about the Unified Patent Court and the Unitary Patent. So in the next hour, our aim is to provide you with the main information about the new system, practical tips, and we'll have some time towards the end of the hour to answer any questions you may have. So as Tarun mentioned, my name's Sandeep Basra, and I'm a German and European patent attorney based in our Munich office, and I'm a part of the chemistry and life sciences team. And my colleagues who are with me today are from the Bristol office, and they are both UK and European patent attorneys. So Nina is part of our engineering team, and Matt is part of our tech team. Matt is also a patent attorney litigator and UPC representative. Today, we will kick off by providing an update of where we are now with the UPC and UP. Nina will then provide an overview of the Unified Patent Court and the Unitary Patent System. Matt will then go into details about the Unitary Patent validations and opting out. So Matt will really guide you through the main considerations of what you need to be thinking about now. And then finally, we will bring this together with a few hypothetical cases and postulate about how applicants and patentees in various industrial sectors may prepare themselves for the new system. So as I mentioned, we'll have time for your questions. So as we go along, please feel free to submit your questions using the Q&A function at the bottom of the screen. So let's start by taking a look at where we are now with the UPC and UP system. So what are the headlines? Well, as Tarun mentioned, this has been going on for a long time, and the genesis has been quite difficult, but the UP and the UP system is almost there. So the system will start on the 1st of June, 2023. So it's really not very much time left. From this date, it will be possible to obtain a unitary patent and to bring actions at the Unified Patent Court. So the sunrise period for opting existing European patents and patent applications out of the UPC's jurisdiction in advance of the UPC has already started. So it started on the 1st of March this year and will run until the 31st of May. So there are a lot of things for proprietors and applicants to be thinking about now, and not much time to act before the system comes into effect. So looking at the latest numbers, the opt-out count stands at about 30,000 at the moment, with more than 1,000 of these requests being filed by our firm, which also includes bulk opt-out requests. We're expecting this number to increase significantly, and we're expecting May to be very busy. So this is why it's very important to get instructions early and for you to be thinking about your approach to the UPC. So before I hand over to Nina, I would like to go through some of the terminology. So there is a lot of terminology associated with the new system, which can be confusing. So this glossary just provides an overview of some of the most commonly used terms. So firstly, the Unitary Patent, the UP. So this is a single right granted and administered by the European Patent Office with effect in all of the EU member states that participate in the UP and UPC system. So there will initially be 17 participating UPC member states, with more expected in the coming years. So the Unified Patent Court, the UPC, so this is a new court for handling disputes relating to unitary patents and classical European patents, i.e. current patents that are not opted out. Then we have the transitional period. So this is a period that will last at least 7 years and possibly as long as 14 years, during which the UPC will share jurisdiction over classical European patents with national courts. More about this to come. After the transition period, the UPC will have exclusive jurisdiction for all UPs as well as classical European patents if they have not been opted out. Okay, the next one is the opt-out. So this is the act of withdrawing an existing European patent or patent application from the jurisdiction of the UPC, so that any disputes relating to the patent can only be handled by national courts. Okay, so this option is available now and up to 1 month until the end of the transitional period, provided that the patent being opted out has not been the subject of proceedings at the UPC before a request has been lodged at the UPC. So Matt will go into more details about this later. But it's important to note that when we were talking about opting out, we're talking only about taking European patents and patent applications out of the jurisdiction of the UPC. So opting out is a process that is performed at the UPC and has no bearing on the process of how to obtain a European patent. Okay. And then the sunrise period. So this is the 3-month period that we're currently in, which immediately precedes the start of the UPC system coming into effect. So now, with that short glossary, keep that in mind, I will now hand over to Nina, who will provide an overview of the UPC and UP system.
Thanks, Sonny. So yes, let's have a look at the new UP system and how it fits in with the current system in Europe. Start with a quick recap of the existing system for obtaining European patents. Most of you will be familiar with this already. So you start with a single European patent application, which is filed at and prosecuted before the European Patent Office, the EPO. Successful prosecution ends with the grant of a European patent by the EPO. After grant, the European patent is validated in those EPC states in which patent protection is desired. So the granted European patent becomes a bundle of separate national patents in the selected countries. I'll be referring to this style of validation as classical European validations from here on in. Post-grant litigation, such as infringement or invalidity actions, are performed in the national courts of the countries in which the patent was validated, so country by country. So that's the EPO system. And although it's not shown on this slide, don't forget that you can also file national patent applications at the relevant national patent offices in Europe. So for example, a UK patent application leading to a granted UK patent can be filed with the UK Patent Office. So when you file a European patent application, it automatically designates all the contracting states to the European Patent Convention, the EPC. There are currently 39 EPC states, which are shown in red on this map. But it's important to remember that a European patent application doesn't just cover EU member states. A subset of the 39 EPC contracting states are members of the European Union. There are 27 EU member states, so that means there are 12 countries who are members of the EPC, but not members of the EU. Some key examples of countries which are in the EPC but are not in the EU are the UK and Switzerland. So now let's have a look at the Unitary Patent system, which will be coming into effect soon. As soon as it starts, the existing patent system will continue as normal with classical validation options upon grant, but a unitary patent will be an additional option for post-grant validation. It will be a single patent covering all of the EU states that are contracting member states to the agreement on a unified patent court. Now, not all EU states have signed up yet. So the unitary patent, UP, when it comes into effect on the 1st of June, will cover just 17 of those 27 EU member states. I'll be referring to the EU states which are members of the UPC system as UPC member states for short. So in Europe, you'll have the option of classical validations or UP validation or both when the patent is granted. And the existing national patent systems will continue as normal separately from the EPO. So let's see how that looks in practice. Again, I will emphasize that the unitary patent system doesn't replace the existing European patent system. It just sits alongside it as another option at the point of grant. So when granted, there'll be two different avenues of validation that the patentee can take. They can use classical validations to obtain a bundle of national rights as normal, as shown in the bottom part of the slide here, or they can validate as a unitary patent, which covers all of the UPC member states, those 17 at launch that I mentioned earlier. And to get the required geographic coverage, they may also classically validate in some countries that are not covered by the unitary patent, for example, the UK, Spain, or Turkey. So while national classical validations continue as normal for the states that are not members of the UPC agreement, for those 17 states which are UPC member states, a unitary patent can be used instead of validating as separate national patents. It's important to note that if you validate as a unitary patent, you can't also validate as national patents in those UPC member states. So participation in the UPC system is only available to EU member states. And as things stand, as I said, only 17 of those states will participate in the UPC system at the outset. So this is a representation of the geographical scope of a unitary patent as it stands. Green shows the EPC member states which are in the EU and have ratified the UPC agreement, and so they will be UPC member states from the start. Yellow shows the EPC member states which are also in the EU but have not yet ratified the UPC agreement. So they will not be a part of the UP system at the start, but they may join later. And grey shows the EPC member states that cannot or will not ratify the UPC agreement, and so cannot be a part of the unitary patent system. For example, the UK, because it's no longer a member of the EU, and Spain and Poland, who, despite being members of the EU, have constitutional objections to joining the UPC. Now, it's worth remembering that even if all the EU member states join the UPC agreement, some key European territories still won't be covered by a unitary patent, such as the UK. Now, this is just a slightly different representation as a Venn diagram of the same information, which might be slightly easier to digest for some people. It shows the EPC states in the largest circle, then the EU states in the next circle, and in the next circle, the subset of the EU states which are eligible to participate in the UPC agreement. Finally, in the smallest circle are those EU states which have already signed up to the UPC agreement, so they are UPC member states. The three highlighted states in the smallest circle are those that had to ratify the UPC agreement for it to come into effect. So how will post-grant litigation work? In the new Unified Patent Court, UPC, they will handle all disputes relating to the unitary patent. And they'll also be able to handle disputes relating to classical validations of European patents in the UPC member states. So to be clear, classical validations in non-UPC member states will still be handled by their respective national courts. It's only for the classical validations of the UPC member states that the Unified Patent Court will have jurisdiction. So decisions of the UPC are effective in all the UPC member states. For patentees, there are major advantages to this. For example, in the event that the UPC finds that a patent has been infringed, it can grant an injunction that is effective in all the UPC member states. So a single infringement action could result in an injunction that's effective in 17 EU member states, which is clearly a very cost-effective way to enforce a patent in multiple states. But this cuts the other way too. A finding of invalidity by the UPC will result in revocation of the whole unitary patent or classically validated patents in all the UPC member states, which is known as central revocation. This potential for the loss of all patent rights in the UPC member states in a single action is the major disadvantage of the UPC system. And it's why an option exists during a transitional period to opt out existing classically validated European patents from the UPC's jurisdiction. Now, the transitional period will initially last for 7 years and is extendable by up to a further 7 years following a review of the system after 5 years. During the transitional period, opt-outs of existing European patents and applications can be filed. If expired or existing granted European patents and European applications are not opted out, then the UPC will share jurisdiction over the classical validations in the UPC member states during the transitional period. Shared jurisdiction means that actions can be brought in either the UPC or the respective national courts of the UPC member states. So there's no need to opt out of the UPC's jurisdiction to bring an action in the national courts for classically validated patents during the transitional period. For unitary patents, the UPC will always have exclusive jurisdiction, and the national courts of the UPC member states do not have jurisdiction to decide on unitary patents. For any patents granted after the transitional period, the UPC will have exclusive jurisdiction for all unitary patents and classically validated patents within the UPC member states, unless the European application was opted out during the transitional period. So the key here is that for European applications filed after the end of the transitional period, there will be no way to avoid the jurisdiction of the UPC for validations in UPC member states, except by filing national patent applications instead of going through the EPO. But since the transitional period could be as long as 14 years, this might not be a problem for a while. So to summarize the UP system, this is a table showing the validation options for UPC member states and non-UPC member states, and the jurisdiction of the various courts during and after the transitional period for each of those validation options. So starting at the top, we can see that for non-UPC member states, the only validation options are the classical validations as a bundle of national rights as normal. Then, irrespective of the phase of the UPC system, the respective national courts will always have jurisdiction over those rights. So for those countries which are not UPC member states, nothing has changed in the European system. Now, for the UPC member states, there are two validation options, either as a unitary patent covering all of the UPC member states, or classical validation of some or all of the UPC member states. For a unitary patent, the UPC will always have exclusive jurisdiction, and it won't be possible to opt out of the jurisdiction of the UPC, even in the transitional period. But for the bundle of national rights, it gets a bit more complex. During the transitional period, if not opted out, then the UPC and national courts share jurisdiction. But if it is opted out, only the national courts have jurisdiction. After the transitional period, the UPC has exclusive jurisdiction over these patents, and new applications cannot be opted out. But if applications were opted out during the transitional period and granted after it, then the national courts will have exclusive jurisdiction. We appreciate that this is quite a complex topic, so we will be sharing these slides after the webinar to give you some time to study this a little at your own leisure. So that was a brief overview of the new UP system. Now on to Matt, who will discuss what you will need to validate a unitary patent and to opt out.
Thank you, Nina. Yes, so now that we know a little bit more about this new system, let's have a look at the mechanics of obtaining a unitary patent and why you might want to do so. So if we go back to our definition from the start of the session, a unitary patent is a single right which is granted and administered by the European Patent Office and has effect in all of those EU member states that participate in the new system. What that means in practice is that to obtain a unitary patent, the first step is very straightforward. We apply to the European Patent Office in the usual way, as Nina said. And then if you want to validate your granted European patent as a unitary patent, you have to request a unitary patent, that is, validate your granted European patent as a unitary patent within 1 month of the date of grant. And that's quite a straightforward process. There is a form that you file at the European Patent Office, which is accompanied by a translation of the specification. Now, if the specification is in English, that translation needs to be into another EU language, whereas if the specification is in French or German, the translation has to be in English. Now, it's really important here to note that there's no extension to that 1 month period. Okay, so we're talking about quite a time-constrained system. If your request for validation as a unitary patent misses a formal requirement of the EPO, for example, if you've forgotten to include the translation, you will get an invitation from the EPO to correct the defects within a 1 month deadline. Further processing of that 1 month deadline isn't available. Re-establishment of rights is, but you have to comply with the European all due care standard, which is a very high bar. So the real key point here is that if you are going to want to obtain unitary patents, you need to act quickly and you need to actually make a decision well in advance of grant of the patent so that you're in a good position to take the necessary steps at the point of grant. So our suggestion here is that a good time to decide on whether you're going to validate as a unitary patent is when you receive the intention to grant communication, the Rule 71.3 communication from the EPO. In terms of costs, there will be no official fees for requesting a unitary patent, but there will be translation costs and renewal fees to be paid. So obviously a key question then right now for all applicants of European patents is whether or not they want to make use of the unitary patent. And of course, there are pros and cons to that. as we've heard from Nina, a unitary patent will be subject to the jurisdiction of the UPC, and that means that centralized litigation at the UPC in relation to that unitary patent will be possible, with the aim of achieving a single decision which will have effect in all of those participating states. And that should be quicker and simpler and more cost effective than pursuing parallel litigation in the national courts of multiple individual states, as you would have to do under the current classical sort of bundle validation system. But the unitary nature of the unitary patent system is its biggest weakness. It makes it vulnerable to this central attack. As Nina said, a central invalidity action at the UPC could lead to central revocation, that is, complete loss of all patent rights in those UPC participating member states. And because the UPC is a new court, we just don't know at this stage how it's going to approach the issues before it. So if you are nervous or hesitant about using a new court, then our suggestion would be perhaps to avoid using unitary patents for the time being and stick with the classical national validation route. As regards costs, our expectation is that validating and renewing a unitary patent will be more cost effective than validating and renewing in more than 4 individual EPC member states. But as we showed on the earlier slides, patent protection won't be available in some EPC states via the unitary patent. So it's likely that additional national validations will be needed in some commercially important states, and that might offset some of the cost benefits of a unitary patent. So really, this is just a checklist then of things that you can be thinking about at this time. For each pending European patent application, think about which countries you are ultimately going to need patent protection in, and think about the sort of shape of validations that you are going to need to achieve that protection. Remember that the geographical scope of the unitary patent is anticipated to increase over the coming years. So what is an appropriate strategy now might not be an appropriate strategy in, say, 3 or 4 or 5 years' time. It may be that now you can't get the coverage you need just with a unitary patent, but in 5 years' time you might be able to. So this is something to keep under review effectively constantly. Remember that national validations then might be required as well as unitary patents to achieve your desired geographical scope of protection. Now, if you know you definitely want to validate as unitary patents for cases that are already at the point of grant or already have been accepted, there is a really straightforward mechanism at the EPO for doing this. So you can effectively just ask for a delay to your grant to make sure that once the patent actually does grant, you are able to validate it as a unitary patent. There's also a mechanism for requesting unitary patents early. So again, if you want a unitary patent as soon as it's available, you can effectively simply ask the European Patent Office for that. And the final point on this slide is that the new unitary patent system gives rise to interesting possibilities for strategic use of divisional applications. There's no reason why you have to validate a divisional application that has been granted in the same way as you validated the parent application. So it's possible, for example, to have a parent application with perhaps quite specific claims targeting a particular infringement, which is validated nationally in individual countries in which that infringement might occur or in which a competitor product might be launched. And then to file a divisional application with perhaps broader claims and to validate that divisional application once it's granted as a unitary patent. So you've got broad claims and a broad geographical scope of protection, which might provide you with a greater deterrent effect for potential competitors. Okay, so let's move on to talk about opting out, what it is, why you might want to opt out, when you should be doing that, and how you actually go about doing it. And again, we'll start by returning to our definition from the start of today's webinar. So opting out is the act of withdrawing an existing European patent or published European patent application from the jurisdiction of the UPC. And the effect of opting out is that any disputes relating to the patent that you've opted out can only be heard by national courts. again, as Sonny said right at the start, when we talk about opting out, we're only talking about taking the patent out of the jurisdiction of the UPC. So opting out relates only to withdrawing from the UPC's jurisdiction. It has no bearing on the process of obtaining a European patent. So, as we've said, once the UPC is up and running, all existing European patents will fall under its jurisdiction, as well as the jurisdiction of the relevant national courts, which means that it will be possible to enforce or to attack a granted European patent centrally through the UPC and to obtain this single decision that's effective in all of those participating member states. And as we said, so the major risk then from the UPC to existing European patents is central revocation, that loss of all of the patent protection in the participating member states as a result of a decision by the UPC that the patent's invalid. During the transitional period, it will be possible to opt existing granted European patents and published pending applications out of the UPC's jurisdiction, so that they only fall under the jurisdiction of the national courts. And the big benefit of opting out in this way is that the risk of central revocation is removed. So you can opt out your European patents at any time during the transitional period, up to a month before the end of the transitional period, unless an action has already been brought in respect of that patent at the UPC. We are currently in the sunrise period, which will last until the 31st of May, during which we can file opt-outs early. And the idea of this sunrise period is that patents that have been validly opted out in the sunrise period will never come under the UPC's jurisdiction. You can only bring an action in the UPC after the 1st, or on or after the 1st of June. So if you opt your patents out during this sunrise period, so up to the 31st of May, those patents will be opted out at the time the UPC opens its doors for business, and so will never fall under the jurisdiction of the UPC, and so won't be vulnerable to this central revocation. Now, you can also withdraw your opt-out, and you might want to do that if, for example, you discover an infringer and you want to pursue them through the UPC to try and get a pan-European injunction, for example. You can withdraw an opt-out once, but you can only withdraw an opt-out as long as an action has not been brought in relation to the patent at a national court. So let's talk now about some practical problems or practical issues around opting out of the UPC's jurisdiction. The first thing, and this is a really important point to note, is that only the true legal proprietor of the patent can opt out. And the true proprietor might be different to the proprietor of record, that is the proprietor whose name appears on the EPO register or a national patent register. That could happen, for example, if there's been an assignment of the patent that hasn't been recorded on the various registers. So if you are looking to opt out, it's really important that you know and can provide the details of the true legal proprietor. In cases where there are joint proprietors of a patent, all of the proprietors must agree to opt out, and the opt-out application has to be filed naming all of those proprietors. So if you are in a situation where you have patents where you are a joint proprietor and you want to opt them out, you need to be looking for agreement from your co-proprietors. And you also need to agree amongst yourselves which proprietor will ultimately be responsible for opting out. Now, there are some traps associated with opting in and opting out of the UPC's jurisdiction. If you've opted out your European patent from the UPC's jurisdiction, you can only withdraw that opt-out if no action in relation to the patent has been brought in the national courts. So, as I said, you might want to do that if you discover an infringer that you want to pursue in the UPC. Now, there's a risk there that if an action is brought in a national court after you've opted out, so for example, an action for a declaration of non-infringement brought by your potential infringer, you'll be stuck in the national courts with all of the associated cost and complexity of parallel litigation if you want to enforce your patent. So really, it's about being aware of these potential issues when you opt out, and being aware that if you might want to pursue litigation in the UPC, it might be worth not opting out at the outset. So then, A key question, obviously facing all patent holders right now, is whether or not they should opt out. And there are going to be a number of factors that will play into the decision as to whether or not to opt out. There will be factors to do with litigation. How comfortable are you with your patents being vulnerable to central revocation? Are you going to want to use the UPC for infringement actions to seek a pan-European injunction? One option there is perhaps to opt out and then opt back in if needed. But again, be aware of that potential trap of being stuck in the national courts if a national action is brought after you've opted out. There are going to be some budgetary and administrative factors associated with the decision as to whether to opt out or not. You're going to need to do an internal audit of your patent portfolio to identify your own European patents, any patents that you are licensing in, and any patents that you are licensing out. And you're going to need to check on your ownership position because, as I said, only the true owner can opt out. Again, if you have got cases where there are joint proprietors, you're going to need to have discussions and decide together, because an opt-out request has to be filed on behalf of all of the proprietors. And you're going to have to think about how you're going to deal with requests from any licensees to opt out, or perhaps not to opt out, patents that they're licensing from you. And obviously all of this comes with an admin overhead and an associated cost. So you're going to have to keep those factors in mind when you're deciding whether or not to opt out. In terms of timing of opt-outs, this slide gives us a sort of graphical indication of the current status of the UPC. And the key point on this slide really is when opt-outs can be filed. We're currently in this sunrise period during which we can opt out in advance. As we said, this last 3 months, it started on the 1st of March. And from the start of the sunrise period, opt-outs can be registered in advance to protect your existing European patents from the jurisdiction of the UPC and therefore from the threat of central revocation. But the option to opt out doesn't stop at the end of the sunrise period. The option to opt out runs all the way to 1 month before the end of the transitional period. Having said that, though, remember that a patent can only be opted out as long as it's not been the subject of an action at the UPC before you requested the opt-out. And that's why opting out in the sunrise period is beneficial. No action can be brought at the UPC before the UPC opens its doors on the 1st of June. So if your opt-out request is validly filed by the 31st of May, it can never, the patent you're opting out can never fall under the jurisdiction of the UPC. But it's not a disaster if you don't manage to get your opt-outs in during the sunrise period. You can still opt out during the transitional period, but our recommendation would be to do that as soon as possible. Okay, so in terms of the mechanics of opting out, how do you actually do it? Well, there are two options. The first one is to do it manually via the UPC's case management system, which is accessible via a website. That can be done by the patent proprietor themselves or by a representative. In order to access the UPC's case management system, you need a strong authentication device, which is compliant with the eIDAS authentication standard. Typically, that's a smart card. Once you've got your authentication device, you have to register with the UPC case management system, and then you have to log in and enter the patent details manually on a case-by-case basis. You also have to upload an opt-out application document, which contains a declaration as to the true legal ownership of the patent. And if the person lodging the opt-out is not the patent proprietor or is not an authorized representative before the UPC, they have to also file a mandate which declares that they are authorized to lodge the opt-out on behalf of the proprietor. The alternative is to use an automated process using APIs that have been provided by the UPC. And at Hazeltine Lake Kempner, we've developed an automated process which is pretty effective and pretty quick and accurate. So if that's something that you're interested in doing, please do get in touch and we can talk you through how we go about that. That system is very useful for bulk opt-outs. As an example, I filed 800 plus cases in a single action a couple of weeks ago. There are a couple of really important points to note on the opt-out system. So the first is that the UPC's rules of procedure say that an opt-out only takes effect when it's been registered. So it doesn't take effect on filing. It only takes effect when it's been registered. Now, our experience so far during the sunrise period is that opt-out requests are being registered pretty quickly. It's almost instantaneous. But we do have some concerns, as Sonny said right at the start. At the moment, the number of opt-outs that have been registered or that have been filed stands at about 30,000, which is, to me, actually quite surprisingly low. Our expectation is that as the sunrise period goes on, we're going to see more and more opt-out requests being filed. And certainly towards the end of the sunrise period, we're expecting tens of thousands of opt-out requests to be filed every day. And it remains to be seen how the UPC's case management system handles that. It's possible that there may be delays in registration as the number of opt-out requests being filed concurrently increases. So again, the recommendation here really is, if you are filing opt-outs, do it as early as possible to really minimize the risk that you might get caught in delays at the UPC end in registering those opt-outs. So with that, I will pass you over to Sonny to give you an update on things to think about now.
Thank you, Matt. So yeah, to bring all that together, I'd like to summarize things to think about now. So applicants and patentees really need to think about which patents and applications to be opted out during the sunrise period. And again, remember that opt-outs can only validly be requested by the true owner of the EP, patent, or application. So the true legal owner or owners need to be identified. And in case of joint ownership, you need to make sure you have an agreement with all the proprietors. Further point, if you're a licensor, then it's likely that your licensees will be concerned about the possible impact of the new system on their business. So be prepared to discuss the opt-out strategy with your licensees. But remember, it is the true proprietor of the patent only the licensor that is entitled to opt out. So you should also be thinking about a strategy for your pending applications. So how would you handle validations once after the 1st of June? So will you continue with the status quo of the national validation, so the bundle of patents, or use the unitary patents or the unitary patent, or the unitary patent in combination with national validations for the desired geographic coverage? So this all may well be case dependent. So it is advisable to think about developing some criteria to help you think about the validation strategy. For example, some of the most important patents, so those that protect the key features or are associated with large revenue streams, they might need to be validated nationally and opted out to protect them from the UPC central revocation. Whereas less important cases may be validated as unitary patents for cost and geographical scope reasons. So also think about filing targeted divisional applications, as Matt mentioned. So for example, you could have a broad unitary patent for wide geographic coverage and a more targeted divisional covering known or anticipated competitor products or specific important features. So this could then be opted out and validated nationally. Finally, delaying grant is now possible for cases deemed allowable, which would otherwise grant before the UP is available, and this is a simple procedure at the EPO. So we'd now like to provide 3 hypothetical case studies to bring a practical context to what we have been presenting today. The first scenario we have come up with is a multinational pharmaceutical company. So they typically have, it's typically a very highly competitive market, and they usually have a significant IP budget at their disposal. The market is often European, it's a Europe-wide, and the patent portfolio is generally made up of European patents protecting single active agents, which could be a blockbuster drug, and secondary patents relating to, for example, formulation and use. So this sector is often highly litigious. So how do we think that a multinational pharmaceutical company would use the new system? So we expect them to opt out of existing granted patents we'd expect them to opt out existing granted patents and pending applications during the sunrise period to avoid the risk of central revocation of key patents. We also expect them to continue using the existing system and validate upcoming patents nationally. Again, by opting out of the new system, they avoid central revocation of their key patents. Having said that, they may consider unitary patent validations for less important innovations. So finally, after the end of the transition period, multinational pharmaceutical companies may well consider switching to national filing model for key innovations. And again, this is a way to avoid the central revocation threat of the UP. Now over to you, Nina.
Thanks, Sonny. So in my example, we're going to be looking at an industrial engineering SME. Now, this sort of company might typically protect multiple features in any one product that they have with multiple patents. So each patent wouldn't necessarily be vital on its own. They might have a very limited IP budget, certainly compared with the pharmaceutical company in the first case study, but quite a large European market. For example, including the countries I've listed, where 4 to 5 countries, those which are highlighted, are UPC member states. These companies are not typically hugely litigious in that they're rarely required to assert their rights, and the risk of revocation action against them is also quite small. So what might a company like this do? They would likely consider opting out their existing granted patents for the same reasons as the pharma company would, and especially because you don't get any of the positives of the UPC in the lower costs of the unitary patents, since these patents are already granted, so they're just a bundle of national rights. For future patents, they might consider unitary patent validation for most of their cases to achieve that greater territorial coverage. But in some situations, they might just consider using the classical national validations, for example, for strategically vital patents, where they might opt out of the UPC to avoid that central revocation risk. But similarly, they might choose to use the classical national validations for low-value patents, where, for example, they'd be happy with fewer than 4 national validations in the UPC member states, since it would be much more cost effective then to go down the national validation route than to get a unitary patent. They may choose to opt out those patents, but could still choose to opt back in if they wanted to use the UPC at a later date, of course, assuming that an action hasn't already been brought at a national court. But especially because asserting their rights might be more cost effective before the UPC, that might be an option. So that sums up the industrial engineering SME, and over to you, Matt, for our last example.
Thanks, Nina. Yeah, so in this last case study then, it's a hypothetical consumer electronics company. This is a multinational company with a significant IP budget and a Europe-wide market. Typically, these kind of companies use patents to protect key product features. And it's not uncommon for these kinds of companies to validate in Germany, France, the UK, Ireland, Italy, and the Netherlands, for example. This is a company that rarely asserts its own patents in litigation, but has done and has sought injunctions and damages, and has been on the receiving end of revocation actions in the past. So what are our suggestions for a company of this kind? Well, perhaps unsurprisingly, we're suggesting that they might want to consider opting out all of their existing granted European patents, again, to avoid the risk of central revocation of key patents by competitors. And we're suggesting that they might want to continue their national validation strategy for their strategically most important patents, again, opting out to avoid the risk of central revocation. But perhaps a company like this would also consider a dual unitary patent and national validation strategy with targeted divisional applications. So perhaps looking to obtain broad unitary patents to have a wide deterrent effect, but with national validations of perhaps more focused divisional applications targeting specific competitor products or potential infringements in key markets. In terms of less strategically important patents, perhaps this company would be considering unitary patents, again, for greater territorial coverage and to provide the threat of cross-border injunctions if enforcement is ever required. So with that, we'll move on to the final part of the presentation, which is a question and answer session. Sonny.
Thank you, Matt. Yes, there's a lot to discuss and a lot to think about. And we've managed to leave a few minutes at the end of this session for your questions. So thank you very much for all your questions during the session. So let's kick this off with you, Matt. So the first question that came in was, how will litigation be handled at the UPC? Do I need to use a specialist UPC litigator?
That's an excellent question and worthy of a webinar of its own. The short answer is that yes, you will need to use specialist UPC litigators, but actually European patent attorneys who have particular litigation qualifications are also qualified to litigate at the UPC. And within HLK, we've got about 40 attorneys who meet those criteria. So our approach will be to have a sort of co-counselling arrangement where we will have cases for our clients will be handled by a European patent attorney who is an expert in the subject matter, a technical expert. What we have is a panel of litigators, litigation firms that we have really good, strong relationships with in all of the countries, all of the European countries where there is a court of the UPC. And our approach will be to assess each case on its merits and basically pick the best and the most appropriately qualified litigation firm in the country in which the litigation is going to happen, with the aim of really, having a technical expert handling the sort of technical questions on which things like infringement and validity are going to be turning. So you've got a European patent attorney who understands your technology and understands the law that's going to be applied, and then bringing in specialist local kind of litigation support for the later stages of the proceedings, for the trial and the oral advocacy, to really sort of tailor the presentation of the case to any specific national requirements or nuances that might be present in the court in which the case is going to be heard.
Thanks, Matt. Here's one for you, Nina. We had a question. If I get a unitary patent, will it automatically be extended to cover new countries as they join the system?
Well, the short answer to that is no. Essentially, the unitary patent covers those countries which are in the system at the time that you validate it as a unitary patent. Because at the same time, you'll have the option to validate as a classical national bundle of rights in those countries that are not covered by the unitary patent. So if the unitary patent were to allow an extension later, then you might end up in a situation where you'd have double patenting with a national right and the unitary patent. So it doesn't extend to other countries after they've joined the system. After you've validated and they've joined the system afterwards.
Thanks, Nina. We've had a couple of questions about the interplay of the UPC and EPO opposition proceedings. So Matt, here's one question for you. What happens if an invalidity action is brought in the UPC against a patent that is being opposed at the EPO?
Yeah, it's a good question. There's nothing to stop the UPC and the EPO running those proceedings concurrently. There are provisions in the rules which say that the UPC can stay its own proceedings but there are also provisions which say that it can continue with them, especially if it thinks that it can reach a decision more quickly than the EPO. And if you think about EPO opposition proceedings, and particularly opposition appeal proceedings, can take years to conclude. So my guess is that in that situation, the UPC would proceed with its own invalidity proceedings, even while opposition proceedings are ongoing at the EPO. Interestingly, there is a provision in the rules which says that the UPC, in those circumstances, can make a request to the EPO to speed up its proceedings, which will be an interesting bit of extra pressure on EPO opposition and appeal boards.
Thanks, Matt. We've also had a question about EP patents that have been through and survived opposition proceedings at the EPO. And what are your thoughts about opting out such patents?
Yeah, I mean, I think there are really two schools of thought on this. There's the safety first approach, which would say, look, opt everything out. If it's a patent that you would be upset or badly damaged by losing in a central revocation at the UPC, just opt it out. There's a second school of thought that says, well, actually, look, if it's survived EPO opposition proceedings, and particularly opposition proceedings where there's also been an appeal, it's probably in pretty good shape and pretty robust, because EPO opposition proceedings are fairly hard work for patentees, and for patent it's only about a third of all granted patents that actually survive an EPO opposition unscathed. So you might think, well, look, if we've got through an EPO opposition and the patent has survived, then maybe it's not so important to opt it out of the UPC's jurisdiction, because a challenge at the UPC may be less likely to succeed. So I think there's two ways of looking at it. For me personally, because opting out is actually a relatively straightforward thing, I would be looking to opt them out. But I can see that, if you've been through an EPO opposition and survived it, you might feel confident that your patent could also survive central revocation proceedings at the UPC.
Thanks, Matt. We have had a couple of questions about avoiding the UPC or strategies after the transitional period. So, Matt, if I could stay with you, and if you could address possibly this last question, what will be the strategy for new patents filed after the transitional period?
Again, that's a massive question. I guess it's going to depend on your commercial objectives. After the transitional period, yeah, all European patents will be subject to the jurisdiction of the UPC. But remember that the transitional period could last up to 14 years. And certainly the aim is that by the end of the transitional period, we'll have a much better idea of how the UPC is going to approach questions of infringement and validity. So, I mean, I guess it's not much of an answer, but my answer would be watch what happens in the UPC during the transitional period, and assess the risks of being subject to the UPC's jurisdiction when you can't avoid it. If you are uncomfortable with the risks of being within the UPC's jurisdiction and not being able to get out of it, then the only option actually is to move away from a strategy where you file at the EPO and move to individual national patent filings. But as I say, after a 7 to 14 year transitional period, it may well be that everybody is a lot more comfortable with the way that the UPC deals with things and has confidence that they could defend patents at the UPC if they needed to.
Thank you, Matt. Yeah, and thank you again for all your questions. We haven't been able to get around to all of them. Many of them we hope were answered during the course of the webinar. But if you still have any remaining questions, feel free to reach out to us. Here are our contact details. As Nina mentioned, you will be receiving a slide deck to be able to go over the material we covered today in more detail. And that just leaves me to thank you all for attending.